There's a place in America where you could get away with murder, and it's not hidden. Imagine you're hiking Yellowstone's Beckler River Trail. You're deep in the woods, 10 miles from the nearest road. You cross a small, unmarked creek, and without knowing it, you've stepped out of Wyoming and into Idaho. The trees look the same, the air is just as thin, but legally, everything just changed. And it's known as the Zone of Death. Out here, most people worry about bears, not the Constitution. But that's the thing they should be worried about. Because in this specific patch of forest, the law doesn't fail because it's weak, it fails because it follows its own rules perfectly. And that's where this gets dangerous. Yellowstone is a highly managed machine, generating hundreds of millions in tourism spending annually. But in this one corner of the park, the system runs into something it can't solve. You're no longer dealing with state law, you're in a federal enclave, which means the FBI and the Department of Justice are the ones in charge. The same document that gives them that power is the exact reason they might not be able to use it. And that's exactly where the problem begins. The Constitution is a list of procedures. When those procedures can't be followed, justice grinds to a halt. And here, one of those procedures becomes impossible. Why does the law fail here? Normally, districts follow state lines. Oregon stays in Oregon, Florida stays in Florida. But Yellowstone is different. Because it spans 3 different states, Wyoming, Montana, and Idaho, Congress made a shortcut. It looked simple, sure, but that decision created a problem no one noticed for over a century. The 6th Amendment says a defendant has the right to a trial by an impartial jury of the state and district where the crime happened. One word matters there, and. It doesn't say or, it says and. That tiny word is the problem. Because if a federal crime happens in the Idaho corner of Yellowstone, your jury has to be drawn from people who live in both Idaho and the federal district of Wyoming, which doesn't exist. The Zone of Death in Yellowstone that sits in Idaho has a population of 0. No houses, no hotels, no residents. It's an area roughly the size of Washington, D.C., remote, unmarked, and indistinguishable from the rest of the park, which means no jurors. Not from Idaho, not from Wyoming. There's literally no one you can legally call for jury duty. If you can't form a jury for a serious crime, you can't proceed with the trial at all. It's a perfectly legal loophole hiding inside one of the most famous national parks in America. This trap only snaps shut for the most serious offenses. Speeding ticket, illegal camping, no problem, a judge can handle that. But anything carrying more than 6 months in prison, the Constitution guarantees a jury trial. So out here, they can't legally move forward. The law itself is the only thing standing between crime and punishment. A poacher with a high-powered rifle, or someone fleeing from another state. Every plan, every step, is executed knowing the law can't follow. In this void, the ordinary rules of justice vanish, replaced by the eerie logic of procedural impossibility. It's not a glitch in the system, it's a full stop. For over 100 years, this problem went unnoticed. Then, a law professor named Brian Kalt found it. In 2004, he was just studying the 6th Amendment and the way federal districts were drawn on a map. But then he noticed something impossible. The lines extended into Montana and Idaho. Forming a jury there was a constitutional impossibility. He wasn't excited. He was horrified. It was a place where the Constitution required something that physically couldn't happen. Few other countries allow such a legal loophole to persist inside a national park. In Canada, for example, national parks fall under provincial or federal jurisdiction, but trial districts are always drawn to ensure a jury can be convened. Even in the most remote areas, governments plan for contingencies. The US stands out because the Constitution is absolute, but absolute rights collide with physical geography, creating a loophole unique in the developed world. In 2005, Kalt published a paper called The Perfect Crime. Not to encourage it, of course, but to force someone to fix it. He sent copies to the Department of Justice, the U.S. Attorney in Wyoming, and members of Congress. He expected a quick response. Instead, he got silence. The Department of Justice took an unofficial stance that essentially ignored the problem. The loophole didn't exist until a court said it did. They argued they could move the trial or find a workaround, but Kalt knew that's not how the Sixth Amendment works. You can't simply move a trial because the Constitution is inconvenient. That's exactly what the Bill of Rights was designed to prevent. Kalt began to worry that his paper would become a manual for crime. He had laid out the exact coordinates and the legal arguments needed to walk free from a murder charge. Yellowstone moved from a place of natural wonder to a place of legal mystery. Kalt's paper became a viral sensation, the subject of novels and TV shows. But despite the fame of the Zone of Death, the actual legal status of the land remains unchanged. There's a real-life example of this in action. Back in 2005, a man named Mike Belderrain got caught poaching in the Montana part of Yellowstone. He wasn't a killer, just a hunter who shot a big bull elk where he should not have. When the case got to court, his lawyers brought up Brian Kalt's loophole. They said he should get a jury from Montana, not Wyoming. The judge shut it down immediately. The government agreed to a plea deal. Belderrain got 4 years in prison, plus fines and restitution. As part of the deal, he agreed not to appeal the Zone of Death question to a higher court. This is how the system treats known flaws. Contain the problem quietly, handle the symptoms, and let the loophole persist. The 50-square-mile hole remains mostly untested, a ticking constitutional time bomb waiting in the backcountry. The government got lucky with Belderrain, but the Zone of Death doesn't require a cooperative defendant. It only requires someone who knows the law better than the prosecutor does and the coordinates of a 50-square-mile patch of Idaho that Brian Kalt put on the map for anyone to find. The coordinates are public. The legal argument is published. Anyone willing to do the reading could walk into that forest knowing exactly what the law can and cannot do to them. And for years, this stayed theoretical. And then things started to get real. Let's say, hypothetically, someone studies Kalt's paper for a week. They print the coordinates. They drive to the Beckler trailhead, hike 10 miles in, commit a crime they've planned for months, knowing that when investigators arrive, the first call won't be to a sheriff. It'll be to a constitutional law professor. And that professor will tell them the same thing Kalt told the DOJ in 2005. There is no jury to call. In 2021, the disappearance of Gabby Petito captured global attention. Her body was later found near the Yellowstone region. Suddenly, people started asking, what if it had happened just a few miles west? What if it happened in the Zone of Death? The proximity of such a high-profile tragedy to the Zone of Death stripped away the academic safety net. It made people realize that the Sixth Amendment is supposed to protect the integrity of the system, but when it's broken by a map error, it fails the victims who need it most. The Vallow Daybell case provided an even more direct connection to Yellowstone. Tylee Ryan and J.J. Vallow, the two children of Lori Vallow, were last seen alive on September 8th and 22nd, 2019 inside the park. If the children had been harmed within the zone, the prosecution would have walked straight into a constitutional nightmare. The Vallow Daybell case eventually went through the state courts because the bodies were found on private land in Idaho, but the what-if scenario still haunted federal investigators. In 2022, Idaho legislator Colin Nash tried to do exactly that. He introduced a formal request asking Congress to redraw the boundary. It was the exact fix Brian Kalt had suggested back in 2005. It passed the state level, and then it reached Washington, and nothing happened. This is a failure of the map, and the fix is simple. Move that Idaho section into the District of Idaho. One sentence of legislation, that's it. To the Idaho legislature, this was a matter of public safety. To Congress, it was a clerical error that wasn't worth the floor time. It's a recurring problem in how the federal government handles national parks. Because the land is federal, states have little power to force change. And because the areas are remote, the people in DC feel almost no political pressure to act. You end up with a system where the map is broken, but the people holding the pen refuse to draw a new line. Colin Nash resigned from the Idaho legislature in 2024, leaving office with the zone of death still wide open. Even when a lawmaker does the work, provides the fix, and builds consensus, federal inertia is stronger than the law itself. 20 years, one paper, zero action. The most visited national park in America has a constitutional hole in it, and Washington has known about it the whole time. This isn't bureaucratic incompetence. Somebody looked at the problem, understood it, and decided the political cost of admitting the mistake was higher than the risk of leaving it open. The first reason for this is the lack of political upside. Adjusting a judicial boundary doesn't win elections. No lobbyists fund campaigns for national park boundary reform. The zone of death is a victim of that inaction, a permanent gap in legal protection waiting for the wrong person to stumble into it. The second reason is even more cynical: the fear of admitting a mistake. If Congress passes a law to fix the Idaho zone of death, they're effectively admitting the law has been broken for the last over a century. They're admitting that Brian Kalt was right back in 2005 and they chose to ignore him. In politics, admitting a long-term failure often feels riskier than letting it fester. As long as no one actually walks free on a technicality, Congress can keep pretending this is just a law school hypothetical. They're gambling with public safety to protect their own reputations, hoping the clock runs out before the bomb goes off. The Sixth Amendment is only as strong as the map allows it to be. If lawmakers can ignore a hole in the nation's flagship park, what other gaps exist in the system? The same crime committed a mile apart carries completely different legal consequences. The Constitution doesn't know that, but the map does. In Yellowstone, the law is conditional. Brian Kalt has famously said that the only thing that will fix this is a bloody shirt. Someone will likely have to commit a violent crime, stand before a judge, and watch the case get dismissed because a jury cannot be formed. Only then, when the headlines are screaming about a killer walking free, will Congress feel the heat required to pass one simple sentence of legislation. Until that humiliating public failure occurs, the system prefers to look the other way and pretend the danger doesn't exist. They're waiting for a tragedy to provide the political cover they need to do their jobs, treating a 132-year-old error like it's a minor inconvenience. The Sixth Amendment remains paralyzed in that little sliver of Idaho. It remains a warning for all Americans. If a flaw this obvious can exist in one of the most monitored, high-profile national parks, what else might be lurking in the systems we take for granted? That creek crossing on the Beckler Trail still looks the same, the trees haven't moved, and the law still hasn't either. In the end, that bureaucracy might be the most dangerous thing in those woods. Thanks for joining me today. I hope you enjoyed the video, and if you want to see more videos like this, then please consider subscribing and turn on notifications. It really does make a difference. Thanks again, and I'll see you next time on MapPack.